Well, good evening. My name is Matthew McKnight. I am president of Duke University's chapter of the Federalist Society, and it is my great pleasure to welcome you to another installment in the Federalist Society's Practice Group Study Break series, PG-15. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each practice group is led by a chairman and executive committee comprised of top lawyers from around the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. You can learn more about the practice groups at www.fedsoc.org/practice groups. Tonight, I am delighted to welcome an executive committee member of the Labor and Employment Law Practice Group, the Honorable Kate O'Scanlan. Kate is a vice president and general counsel at the Boeing Company. Prior to joining Boeing, Kate held senior roles both in private practice and in the United States government, including a distinguished tenure from 2018 to 2021 as the United States Solicitor of Labor. In that Senate-confirmed position, Kate served as chief legal officer to the Department of Labor, where she led its team of more than 500 attorneys and staff and oversaw a $132 million budget. At the Department of Labor, she represented the Secretary of Labor and 23 client agencies in enforcement litigation in federal courts and administrative tribunals, and coordinated interagency legal strategy with other high-level officials across the administration, including the White House Counsel's Office, Domestic Policy Office, and Departments of Justice, Treasury, Transportation, Health and Human Services, Homeland Security, Agriculture, and Commerce on regulation and litigation. While in private practice, Kate was a partner in Jones Day's labor and employment practice area, where she counseled clients on various matters, including litigation, investigations, compliance, and regulations. She also spent 12 years at Kirkland & Ellis as a partner and associate, representing clients in complex commercial disputes and class actions, as well as transactional labor and employment due diligence. Kate has a bachelor's degree from the University of Notre Dame, graduating cum laude, and a Juris Doctor from Notre Dame Law School, where she currently serves on the Notre Dame Law Advisory Board. Kate, thank you so much for joining us this evening.
Thanks for having me, Matt. It's been great getting to know you over the last couple of weeks.
Absolutely. It's been a pleasure to prepare for tonight. And as I was getting ready, I was thinking that the tagline for PG-15 is 30 minutes, your questions, their answers. And so true to the spirit of that series, we're going to structure our time around questions and answers. This is also an opportunity for audience members to ask questions, and I would encourage you to do so using the chat function on Zoom. We'll have a time for audience Q&A at the end. Kate, let's start with your background, maybe work our way through some hot topics in labor and employment law, and spend some time discussing the labor and employment practice group, and maybe end with some questions from the audience. Does that sound good?
Sounds great.
Excellent. So let's start with the early days. Could you walk us through your early days of your legal career, your decision to apply to law school, maybe some key decisions in law school that got you started on the path to big law, the Department of Labor, and now Boeing?
Sure. Let me take it one step at a time. I always actually did grow up kind of thinking that I wanted to be a lawyer. And I had some lawyers in my family, and my grandfather was a lawyer. So, but when I got to undergrad, I kind of felt like I wasn't as sure, and I knew that law school was going to be on my own dime, so I wanted to take it seriously. So I worked after undergrad as a management consultant at Arthur Andersen, and I wanted to make sure the business school wasn't a better fit for me. But I pretty quickly, during my time at Andersen, decided that although I was getting a great experience, that it didn't feel like the long-term fit for me or what I like to do. So I ended up working for 3 years before I went to law school. So I valued that, because I think when I came into law school, I had a little bit more of a sort of a serious approach and kind of felt a little bit like, what do I want to do with this next? How am I going to make the best use of this? And so I think, once in law school, I think everybody takes it pretty seriously, or most people do, but I really got to know my professors really well. I got to know my classmates really well. I think that, you want to take challenging classes across diverse subjects because you don't quite know what's going to interest you. I think the hardest thing about law school is that when you're in law school, you feel as though litigation is the only path for a real lawyer. And it's quite the opposite when you get to the real world. There's a lot of counseling aspects there. There's also transactional law, and there's certainly a whole variety of government, public interest, etc. So I think, again, the traditional law school method of teaching, which is great, but using the case method, you think that everything sort of begins with, a complaint and, ends with a Supreme Court decision. And although that is true for a large swath of law, there's a lot of, a lot of things to do with a law degree.
Awesome. That's
so,
a great answer.
Yeah. So I guess that, I a little bit took the easy path insofar as taking advantage of on-campus interviews for, when I was a student, to look at particularly at going to, big law. They come to campus and make it very easy. You go for, you fly back and you get a sense of the place. So I think that that's set up well, but I think that to the extent you want to do something a little less traditional, you just really need to work with your career services and just take advantage of all those other opportunities that are out there, because I think that that's the easiest path, is just sort of what comes to you. So.
Absolutely. And I did not even realize you were a management consultant before law school, because your career has taken so many different twists and turns. You've worked across so many different practice areas, and I tried to write them all down so that I would put them all straight. So catch me if I missed one, but labor and employment, general litigation, commercial litigation, investigations, and compliance, and some mergers and acquisitions work maybe. How did you prepare for that kind of diverse and varied career? It sounds like you're pretty intentional about the decision to go to law school, but is there anything you wish you would have done in law school differently necessarily, going from generalist practices to specialist practices, maybe a class you wish you had taken differently?
Sure. I don't think specifically about classes. I think I took, Fed Court's Choice of Law, some of the harder secondary classes in terms of not sure again exactly what I wanted to do, and then also some of the business courses in case of that. But I think probably the best decision I did was going to a firm like Kirkland that they have a free market system, so you're not tied to a particular practice group. Some law firms you get hired and you are a real estate attorney, and that is your calling. That's the only place you're going to get work. And I feel very lucky that sort of, I don't want to say accidentally, but so intentionally as to the firm by all means, but I didn't realize what a great asset it was to go to a place where I could dabble in different things. And what's kind of funny is that, so I went in, pretty dead set on litigation. And when I had interviewed, when I got my call back from Kirkland, I really hit it off with one of the attorneys who was interviewing me. And it happened that he was the general counsel of the NLRB back in the 1970s. And he and I really hit it off and had a good rapport. And to this day, he is one of my greatest and closest mentors. And when I got in the door as an actual associate, he asked if I could have part of his time to help him with labor employment. Now, what I didn't know at the time was that help labor employment was a big piece of counseling, but also it was M&A transactional work in the labor and employment space. So I actually, got to work on deals with him as a first year, and also have my full docket of litigation, which again, is pretty unique to a firm that would let you do that. Now, I think, which is a good lesson to all law students, in the moment, for the first several years at Kirkland, when I had, hands in both pots, it was fine. And then at some point they said, you're going to be up for partner in several years. You can't make partner both as a corporate partner and as a litigator. So which is it going to be? So I chose litigation. I thought that was good. I think it's always better also to be more general at the beginning to the extent you can. And it's a little bit easier to specialize as you go along. And then I was able to, keep a little bit of hold in labor and employment, because occasionally the way Kirkland does a lot of private equity work, a lot of times that we represent the target and have a wall about particular bidders or vice versa. So occasionally we have multiple clients bidding for the same target, and they would need help with somebody to run another deal team, and because of conflict. So I kind of kept my skills up a little bit in that regard. And then fast forward, after having 4 children and whatnot, I came back and I came back to the firm, and I got put on a TRO, and I was really overwhelmed and stressed out. And my old mentor took me out to lunch and said, what, you don't seem very happy. What can I do to get you to come back to labor and employment? So I talked to my managing partner, and we talked it through, and he let me switch back, because again, I kept a little bit of a hold in. So I think, there's nothing special about me. I think that what's special what I think what everybody should remember as law students is just that if you keep up your relationships, do a good job with whomever you're asked to work for, do a good job with however menial or outlandish or overwhelming a task, and then I think if you have those relationships, you can a little bit navigate your career as it goes along and get have a little bit more flexibility because you've built up some goodwill and relationships and whatnot. And in some things, it's just even being professional, being a good writer, communicating, being in touch. These very simple aspects of being a lawyer really go across the board if you're counseling, if you're you're closing a deal, or if you're litigating. So I think that that's that's one good aspect. And I would just also put a plug. I think big laws have bad reputations, and I think one thing, right or wrong, I think one thing that they do really well is at least my experience being in big law is they train their attorneys really well, and I think that training is invaluable because again, law school teaches you how to think and how to analyze and reframes your brain, which is really which is a really neat experience. But law firms actually teach you how to apply that to to a case, to solving a problem, to getting from A to Z when something comes in the door from a client. And I think that that's having that connection is really helpful. So I think as you're thinking about firms, places that are going to value training, let you second a deposition so you can learn how that is, let you go to court when appropriate to start observing so you can get up on your feet sooner. And I think that those are good things to look at, whether you're looking big or small or public interest or government or whatnot. Those are those kinds of experiences, getting having a deposition, getting to really own a brief. Those are those things you got to get under your belt to give you some good confidence in your lawyering.
Absolutely. And I was going to save this question for later, but since you already brought it up, the kind of public versus private decision that a lot of law students have to think about. It's the first kind of piece of that question was whether a private firm work is really a valuable experience for a young lawyer. And you just answered that. But how did you think about your transition to the public sector and how did that happen? And maybe we can use it as a bridge to talk about your term at the Department of Labor.
Absolutely. So I had always wanted to serve in the government at some juncture. I was sort of anxious to get to the firm right out of law school because I wanted to start a family, and I didn't think about opportunities right out of law school. I wanted to get to a firm and put down roots. And my husband was at the government for the time, but we sort of made a promise to each other that at some point I get to go to the government and he would go to the private sector. And which you can't completely predict or plan these out. You just sort of have to be open-minded and keep your ears open for opportunities. But like many Americans, I wasn't positive that Donald Trump was going to win the election. So I wasn't necessarily counting on a job in administration because I think that it was far from certain who was going to win. And so as soon as he did, though, I think using contacts like the Federalist Society and friends from law school and those relationships I built from years of being involved, again with FEDSOC, I started to get phone calls about, would you be interested in coming to DOJ? Would you be interested in going to the White House? What would you be interested in interviewing for things and whatnot? So, it really came out of nowhere because I guess it wasn't on the plan to know that this would even be an opportunity. And I had thought, maybe if Clinton had won, it would be another 4 or 8 years until I'd get my chance to serve. But obviously, you got to take it was a tremendous opportunity to get to serve President Trump. So I excitedly had a couple of different interviews and then ultimately was offered this job as Solicitor of Labor. So again, I think to you all out there who are who are in law school and you're building friendships and relationships with fellow FEDSOC or other groups at law schools, whatever it might be, just keep those in mind, and that relationships are a big part of ultimate success, I think, in life and in a law career, particularly in client services. So the more people that you can meet and make good impressions on and whatnot, it's really, it will come up at different points in your life, and just, go back to the golden rule, what you learned in kindergarten. And it's, I think that can be really helpful.
Absolutely. Absolutely. That's great advice. And I think the majority of our audience are law students. And so it's really prescient for a lot of us making those decisions. But let's talk about the Department of Labor.
Sure.
It's impossible to describe such a large agency in the few minutes that we have, but maybe we could do a little bit of just an introduction to the department? Maybe an entry
Absolutely.
to the jurisdiction. You mentioned the NLRB,
Yep.
how the DOL interacts with the EEOC or the NLRB
Yep.
agencies, how it all works.
Okay. Well, we'll start, obviously with the executive branch. You've got a ton of sub agencies, the ones that everyone's heard of, like Department of State and, Department of Agriculture and Department of Defense. There's tons of them. So Department of Labor is, I think, maybe the 7th agency. I could be wrong on that, but so the agency's been around though a long time, and there's over 16,000 employees throughout the country. And as I always like to frame it, in its mission, it's taking care of those going into the workforce, those in the workforce, and those who have retired from the workforce. So it's all aspects of employment. And then, so the solicitor's office there is the law firm that is within the law department. And what makes solicitor's office more unique or different from your typical agency is, and that was really attractive to me, having some litigation in my background, is that we have an independent enforcement authority over a bunch of different laws. So unlike most agencies who all enforcement goes through Department of Justice, or they at least have to get permission from the Department of Justice before they pick and choose their what to enforce or when to bring claims. We have our own independent, and that's in the wage and hour space, in occupational safety and health, in the ERISA space, among others. And so that was particularly, that was really attractive that we had that capability. So I think, within the agency, obviously the secretary was my main client, and the White House, sort of your umbrella client. So we worked with different agencies at different times to advance the president's agenda, to make sure that the health and safety, the wage and hour, that all the laws that affect America's workforce were fairly and forcefully enforced. And then we also, things like compliance assistance. What we really believed in my tenure there is that most employers, not all, but most, fundamentally want to do the right thing, and that given that there are limited resources for the federal government, just by design and by nature, we couldn't go after every single non-compliance. We really had to pick and choose of what will make an impact, or who's the worst offender, or whatnot. So I think that compliance assistance became a really important aspect of allowing employers who really want to do the right thing to come and ask questions and say, hey, this is how we're doing things. Do you think this complies with your laws? Or, we had things like letters that you could write into the wage and hour division that would help. You could give a hypothetical of what was going on in your particular employer or at your union or as an employee, and you get some advice back to us about whether or not we thought you were complying. So again, I think that there's all these different aspects of how to use your limited resources when you're there. And then, of course, we had a robust regulatory agenda, and there were tri-agency regs and individual regs that we were doing on, a lot of the hot button stuff like independent contractor and ESG, and all sorts of neat stuff that's going on in the world still today. I think a lot of the Department of Labor, for better or for worse, a lot of the regs flip-flop depending on if Republicans or Democrats are in power. And I think that, that's more so than maybe your typical agencies. So I really wanted to make sure that when we were working on regulations, that we had the authority to do so, that we did so that was consistent with the case law that bound us, that we did it within whatever limited authorities that Congress delegated to us. So we really tried to be thoughtful, because we also saw, we met a lot of small employers and whatnot, and everybody thinks of sort of the big employers out there that have robust legal shops to help them comply with the law or unlimited resources, and that's actually not your average employer. There's a lot of employers that struggle because there's a lot of different things to comply with. I think you mentioned, or all mentioned, that there's 180 federal regulations that the Department of Labor enforces. So And then that doesn't even come close to some of the state and local laws in particular. So just to even stay in business and to have employees in today's world is pretty significant. So we try to be mindful in terms of making regulations that are easy to understand and easy to comply with and whatnot. So
absolutely. Well, and I just to emphasize how broad the mandate is. I saw on the website 180 federal laws affecting 150 million workers and 10 million workplaces. So it's an amazing responsibility. And I have a few more questions, but also before we go forward, I also wanted to encourage anyone who wants to put a question in the chat to feel free to go ahead and do so. But you mentioned compliance. You talked about working with small businesses that may not have resources. And one of the hot topics surrounding small businesses and compliance with labor law is the issue surrounding non-competes. January, FTC Commissioner Chair Lena Khan announced that the FTC has proposed a rule to ban non-competes altogether. Some critics say that the FTC lacks statutory authority under the FTC Act to do something like that. What do you think about the law around non-competes and whether the FTC is overreaching here? Is this inside or outside the scope of something the FTC is allowed to regulate?
So I'd say a couple of things. One, non-competes are not something generally that the Department of Labor regulates, but certainly as a labor employment practitioner, I'm familiar with them. I have been on both sides in terms of challenging them, trying to maintain them, trying to draft them, etc. So I think that they can serve a good function. I think, like all things, the pendulum might have swung too far in terms of making all employees sign non-competes that then actually does stymie competition or not allow someone to quit their job and work somewhere else or whatnot. So I get, fundamentally, I think it's not as black and white as issue as everybody likes it out to be, because I think there's also there's some areas that there's such proprietary and specialized knowledge that you're doing that really to go across the street and go to your competitor would be completely detrimental to this that you're leaving. So I personally feel like in certain spaces, under certain circumstances, for certain high-level employees, there's a legitimate case. But courts have, state and federal courts have increasingly looked more disfavored on non-competes, so for the reasons that we've discussed. And I think that, so it's not, I guess, surprising in some ways to see concerns or to see this issue coming up a lot. I think the FTC has gone too far. You've got two really noteworthy and great former commissioners, Noah Phillips and Christine Wilson, who have come out pretty forcefully against the actual authority of the FTC to actually regulate in this space, in the first place. And then I think that, the notice of public rulemaking and comment, that's the NPRM, which is what, you have to do before you can actually finalize your regulation. You have to give the public the ability to comment and say how it's going to affect businesses and give different voice your concerns before the commission were to finalize the regulation. And I think that I think that it was written pretty darn broadly, and I think there was a lot of comments to that effect. So I would suspect that you'll see some of the big trade associations come out and probably sue on the first day for regulatory overreach, and we'll see what happens. Obviously depends on what happens in that suit, but I think there's enough people dissatisfied between the lack of authority to promulgate the rule in the first place, and then also how expansive the rule seems to be, that there are some concerns. Again, those are personal concerns, not any specific entity, but that's I think there's a reason that the Wall Street Journal editorial page mentions Chairwoman Khan in pretty much every day because of some concerns with what's happening at the FTC.
Well, I appreciate that. I know it's a hot button topic. It's a tough question. I appreciate you taking it and addressing it so thoroughly. I want to get to practice group questions, but I also want to touch on one more substantive issue, which is ERISA. You mentioned ERISA earlier in your remarks, and I know it's based on the Employee Retirement Income Security Act of 1974, minimum standards, for establishing retirement and health plans, but it seems like its own practice group and its own practice area in a way that most law students would never interact with, but I also know it's hugely important and interacts with the Department of Labor. Could you introduce that
Sure.
a little bit?
Yeah, absolutely. So ERISA is a word that is scary to many lawyers and many law students because it's a really complicated statute. I had a gentleman with whom I worked at the Department of Labor who literally has been working on this since 1974. He's still at the department, and he says he still hasn't perfectly mastered it yet. So it's complicated.
Wow.
I'd say it's more of like a tax practice in terms of how, in reality, how the applicability of it, if that makes sense. But why you have practice groups at firms for is because on the one hand, you have people who write plan documents. So you probably have a health insurance plan, maybe as a student, or if you've been an employee before, or maybe you're still on your parents. You might have a retirement account through your employer. So anything, most employees, this statute will touch most employees in all of those ways. So I think that the reason, for example, when you have a big class action for an imprudent investment, which is one of the requirements of ERISA, is that a plan administrator who has large sums of money they've collected from various employees in their plan, if it's invested, it must be done in a prudent way. Because if I recall correctly, ERISA sprung out of the failure, the Studebaker company, which for anyone who went to Notre Dame, was a South Bend company, was an old car company. They had a bunch of retirement plans that when the company went bankrupt, all of their employees were left with no retirement, pension, etc. So I think this was Congress's response to that, to say, okay, if employer-based savings are happening for retirement, we need a little bit of a watchdog, or we need a big watchdog, I suppose, that's making sure that whomever's in charge or is charged with maintaining the fidelity of it has to be doing so in a prudent way. So there's all sorts between health and welfare and retirement. There's all sorts of litigation for bad actors, for misinformation, for not being forthright with employees. And it's just really complicated, I guess. So I think those who love it should do it because it is a full employment act. They'll always need ERISA lawyers, and there's always regulations at the margins that are changing that I understand. But I think though it's a great, I have a lot of friends who love to delve in. There's great brief writing. There's a lot of I think one of the years I was at the Department of Labor, there were 3 Supreme Court cases that had to do with ERISA. So if you think about how limited their document is, that 3 of them were ERISA related. To the extent you're interested one day in doing a federal appeals court oral argument, that's a really great area where you can distinguish yourself, just because there's not a ton of people that do it, and there's a lot of opportunities. So I guess my takeaway is, don't be afraid of ERISA if you're finding yourself liking it, because I think for many people it's pretty exciting.
Sure, absolutely.
But I think that's an area where you really do specialize. Like there are a lot of people who dabble in other stuff and ERISA. It's sort of generally, it's like, with a few exceptions, actually. Secretary Scalia actually has had a practice in ERISA and a whole bunch of other regulatory stuff, but not everybody can sort of pull that off.
Wow. Well, thank you so much. That is the most thorough explanation I've heard of ERISA in my entire time at law school so far. And I know it's an important practice area and affects, as we talked about, millions and millions of people. So I appreciate it. And I see us coming short on time. So I think let's jump right to a question about practice groups.
Sure.
What is the Labor and Employment Law Practice Group? Can you describe maybe the work of the group and your involvement in it, how it's affected your legal career positively at all?
Sure. So I joined the group right after I left the department. I took a few months off before I went to Jones Day after the term administration. And it's a group of diverse practitioners who love labor and employment law, who do all sorts of areas of labor and employment, on all sides, and who I think generally are just keeping their ear to the ground about regulatory changes, about concerns their clients are having, things they're reading about in the newspaper, things that that Congress is considering and whatnot. And that goes all the way to the labor side. That's a little more the NLRB practitioners and union side, to more, independent contractor, and, to ESG. It's a big, it's a big, wide, diverse group of ideas and whatnot. And I think, we bat ideas against each other. We meet once a month. I think, as new, I'm assuming, I haven't, I've only been part of it since this last administration, but I assume if there's a change in administration, or a new administration, Democrat or Republican, that will again help educate people, or just stay abreast of what is changing in this area and what the developments are. So it's just been a great way to make friends or continue relationships that I made, and then also draw on some past experience of former people who served in the government as well. So.
Well, that sounds great. That sounds like something that's valuable, both from a networking perspective, but also just from a continuing education perspective. So thank you so much. And I'm seeing we are at time, we're getting the hook. So thank you everyone for joining us. And a sincere thank you to Kate for sharing your time and wisdom with us this evening. I've enjoyed the conversation and know it will be informative both to those on the call, but also those who are watching asynchronously via YouTube or Facebook or wherever else it's being broadcast. Before we break, I'd like to plug next week's installment, which will be hosted by my friends at Texas A&M, and will focus on career pathways in antitrust enforcement. You won't want to miss it. So thanks again for joining us, Kate, and good night to everyone else.
Thanks, Matt. Good night.